Welcome back. Now, the Hawks have confirmed that 4 dockets, have been opened to investigate possible high treason. The complaints were made by 4 separate individuals, citing concerns about the spread of misinformation on South Africa's Land Expropriation Act, among other issues. Now, the complaints come on the back of a recent trip by AfriForum as well as Solidarity. They went to the United States in order to meet with a White House delegation over what is known as Afrikaner issues. Joining us to unpack is Dr. Llewelyn Curlewis, a senior lecturer at the Faculty of Law at the University of Pretoria. He's also deputy chairperson at the Legal Practice Council. Dr. Llewelyn Curlewis, thank you so much for the time. Appreciate it. I'm hoping that this also becomes educational because I think we need to be understanding this a lot more. You're the expert on this one. What exactly is treason and high treason in South Africa?
Well, there's a couple of issues that we need to unpack for a start. First of all, obviously, high treason is a very serious crime, and the reason, therefore, is that it can only be adjudicated in a high court. In other words, only our highest courts in the country is equipped to deal with these type of crimes. That for a start. It is a common law crime. In other words, it's a crime that is as old as our law itself, dating back to the Roman and the Roman Dutch law. But since the advent of our constitutional dispensation, South Africa only had but one high treason court case, and that was the former case of the so-called Boeremag trial. That is also the longest South African criminal trial, to the best of my knowledge, that have taken place in this country. That being said, the ethos of political expression necessitates a very strict, or rather narrow, interpretation of what exactly constitutes this crime. And many legal scholars over the years have criticized South Africa's treason law in its present form as so-called anachronistic and inappropriate for a modern popular democracy. The reason for that being that if one looks at the definition, and by all means there are more than one definition that one can identify, and sometimes some of these are very vague and embarrassing for that matter. But the most popular, let's call it the definition of treason, is where a person commits a conduct, whether directly or indirectly, in other words, so-called commissio or omissio, and by doing that, owing an allegiance to the Republic of South Africa with the intention to overthrow the government, and that is very important, the intention to overthrow the government, or coercing the government by violence into some act or inact, then you are guilty of high treason. In short, to give you an example of it in practice, if the 4 accused in this matter of AfriForum and Solidarity plotted to conspire with the United States, and on the assumption, and this is for argument's sake, let's say the USA was in an external enemy of South Africa or in a time of war with the United States of America, then by all means, that would have been, if there was an imminent attack on South Africa, that would have constituted treason, what they have done. But the 2 key elements here, well, there's actually 3. The one is there must be allegiance to the country, which I have no doubt in this instance is applicable. But the other 2, I'm not sure that there have been proper compliance to those 2. The first being there must be some kind of a intention. The intention must be of a hostile nature. In other words, like the Romans called it an animus hostilis. That is more than just a subjective element of our element of guilt that we otherwise always seek for before we can convict a person in this country, because it's part of the definitional elements of the crime. In other words, an accused must have had the intention to overthrow the state, and I think this is where the people sometimes miss the plot. I cannot see from what these 4 or 5 individuals, what they have done, their intention was necessarily to overthrow the government. The mere fact that they might have participated in an event that has a political opposition towards the government or the ANC specifically in mind, or even to work towards the replacement of the government or of the day by constitutional means, say, for example, freedom of speech, freedom of assembly, and well, these are all our democratic principles that we rely on every day in terms of Section 35 of our Constitution. Means that not only did they not have the intention to overthrow the government, but they also did not act unlawful. So those are the two crisp questions that I'm unfortunately have to mention that in my mind does not comply with the requirements for a successful possible prosecution and ultimate conviction on high treason.
Okay, so Dr. Curlewis, according to your understanding of it and according to the definitions that you've then pointed forward, ultimately the MK or any other parties that have filed these 4 cases ultimately don't have a case then. What would be the right case for a situation like this? Is there any sort of rule even broken here by AfriForum and Solidarity?
Yeah, look, one must be careful. There are a couple of criminal activities that one can commit against the government of the day or the state, if you'd like. Such acts can very easily overlap with other crimes that we typically find in our law. For example, public violence, sedition, even terrorism in certain instances. But high treason is more serious than these others, and especially more than sedition, for example, because the aim must be to overthrow the government and not merely to challenge the authority of the people responsible to run the country. So that's the first distinction we must always have in mind. Do not confuse high treason with some of these other crimes. That being said, if it was a crime, this high treason and what the conduct that have been committed by these 4 individuals, then we will have a democratic issue here at hand, because it will be a conundrum in our Constitution, because on a daily basis, we see some of our political leaders and political parties that criticize the government left, right, and center, and rightly so, because those are the pillars of a democratic society. If we do not like it, or if we do not like freedom of speech and the freedom to even attack verbally or otherwise by means of some propaganda the government of the day, then we must get rid of the Constitution and we must go back to some dispensation of 30, 40 years ago, because the two cannot stand next to one another. From that, my initial remark to say, but the modern school of thought is that our current high treason definition and form of a crime is outdated and maybe even should be reconsidered in totality. I
mean, that's what I was about to ask you then. Do we need to relook at the Constitution, particularly with regards to the look at treason, overthrowing, coercing the government ultimately as well as being a key proponent to this, and add in other elements to this as well? Would this be the precedent that needs to be set from this case?
Yes, if we look at case law that we've seen over the last couple of decades where there were successful convictions of high treason, and I'm thinking here cases like State versus Hogan in 1983, if I can remember correctly. There was the matter of State versus Banda and others in 1989, Zwane's case of 1989. Then it's very clear that in order to facilitate a conviction, more than a mere let's call it criticism towards the country and the government is required. Like I said, they call it an animus hostilis, which is exactly what it is. It's a hostile intent, more than a subjective intent, just to put the government of the day on the stake, so to speak.
Yeah, I think that kind of tells you then that a relook perhaps needs to really happen with regards to this then. Dr. Curlewis, let's just finally talk about overall when it comes to cases like these. I mean, we've had some unsuccessful attempts in October 2015, 6 UCT students and the Fees Must Fall protests. You know, they were charged with, or weren't ultimately charged with high treason in the end with that. You had the Julius Malema case as well, which sits there. According to the Helen Suzman Foundation, there were a few other cases that were at play. How do we get a sense of understanding of the kind of case that should be brought forward for particular crimes. Is that lacking? Is it just a case of not knowing the law sufficiently in this country?
Yeah, I must say I'm very concerned if the hawks from the outside immediately identify this possible transgressions as high treason. One must be careful not to confuse it with other crimes that are way easier to prosecute in this country. And I'm thinking of public violence, sedition, and so on, where a mere challenge of the authority might in some instances constitute a crime in itself. But to go for the jugular instead of maybe a more watered down crime in comparison, that might ultimately result in no conviction at all. So definitely we have to educate our prosecuting authority and maybe even our police force to ensure that when they decide to take a matter to court, they do not necessarily always go for the most serious of crimes that they can think of in an hope that something will stick in court and nobody else will pick it up. Because these days, one must be certain that with internet and Google and all the technology available, even laypersons do know and can read for themselves to figure out whether they have complied to the elements of a crime or not. You don't need a lawyer to read. That being said, obviously, I do think there is some education that must take place on some level to sort this out once and for all. And then definitely, I also agree, we have to relook at the definition of high treason, and maybe this time around, instead of relying on 2,000-year-old crime of our ancestors, we might relook at and create a statutory offence of some sort that might then take care of the business of the day.
I can certainly assure you, Dr. Curlewis, that you've certainly helped us get a little bit more education with regards to this. So really appreciate your time this morning. Thank you so much, Dr. Llewelyn Curlewis, then, who is a senior lecturer at the University of Pretoria as a Faculty of Law. He's also the deputy chairperson then at the Legal Practice Council.